Picture this. A group of friends, 6 of them, serious people, hardworking. They pooled money for almost 2 years, planning to buy a small block of flats. The plan sounded simple. Everybody contributes. They buy, they rent out, they share profits. Then one day, one of them calls me sounding stressed. Barrister, we have a problem. The seller says only one person can be on the title. So we picked the most trusted person. Now 2 people are already arguing. One is saying, if the title is in one person's name, how do we know we are safe? If anything happens to the person holding the title, what will happen to our investments? And that is the moment where many group property deals die. They become future court cases waiting to happen. So in this video, I want to show you a clean, professional way groups can buy properties without turning friends into enemies. You use a company, not because it sounds big, not because it is fancy. You use a company because it gives structure, it gives clarity, and it protects everybody, including the person doing the heavy lifting. But let me show you why this matters with one of my clients' story. A few months ago, I had another set of clients, also a group. They bought land together. They did everything by trust. No company, no proper agreements. They just had WhatsApp chats, bank transfers, and one person's name on the documents. Then the property started appreciating. That is when the drama started. One member wanted to sell, another member wanted to hold. Another member stopped answering calls and started bringing strangers to inspect the land. The person whose name was on the document was now receiving threats from both sides. When I looked at their documents, I told them the truth. Gentlemen, you did not buy an investment. You bought a dispute. Now let's fix that problem before it starts in your own life. Here is a simple idea. A company is a separate legal person. That means the property belongs to the company, not one individual in the group. The people in the group own shares in the company, and the company owns the property. So rather than trusting one person to hold the land for 10 people, you are trusting a structure, and you are backing that structure with contracts. Now I know what some people are thinking. Barrister, are you saying we should just register a company, buy property, and that is all? No. If you register a company, and you do not put the right agreements in place, you have only created a new way to fight. The secret is not only the company, the secret is documentation and the decision-making rules around the company. So let me walk you through the way I explain it to clients. First, you must answer one question. What exactly are we doing together? Are we buying land to hold for 2 years and sell? Are we buying a building to rent out monthly? Are we buying apartments and doing short lets? Are we buying land for development? Because the plan determines the structure, and the structure determines the contract. Now let's go step by step, the way a proper group property purchase should be done. Imagine you have 10 people and you want to contribute money and buy a property. Step 1 is a clear agreement amongst yourselves before collecting any serious money from each other. I've seen people collect 50 million first, then start arguing later. That is backward. The agreement should cover simple things like how much is everyone contributing? When is everyone contributing? What happens if someone fails to pay? Who will be the directors of the company? How will decisions be made? When do we sell? How do we share rent? How does someone exit? Can someone bring in a new person to replace them? Now, at this early stage, you can start with what I call a term sheet. It is not the full bulky agreement yet, but it is a written summary of what everyone has agreed to and signed by everyone. This alone solves many problems because it forces everyone to talk about the hard parts before money enters. Let me give you a real life scenario for a client's matter I handled. A group wanted to buy a property. They agreed casually that everyone should contribute equally. Then one person contributed more and started saying his vote should count more. Another person said no. We agreed equal partnership. That small argument nearly collapsed the entire plan. So what did we do? We settled it properly by writing it down. If contributions are equal, shares are equal. If contributions are unequal, shares reflect unequal contributions. Or if they want equal shares but unequal contributions, then the extra money becomes a loan to the company, and the company will repay that person first based on a clear repayment plan. You see the difference? Same group, same property, but 2 different structures. And the structure changes everything. Now, step 2 is incorporating the company. In Nigeria, this is typically a private company limited by shares. Your lawyer handles the corporate affairs commission process, sets the objects of the company properly, appoints directors, and structure the shareholding. And please do not make a mistake here. The company must have the right objects. It must be allowed by its purpose to acquire, hold, lease, manage, and sell properties, depending on your plan. Now, after incorporation, you can open a corporate bank account. Not a personal account, a corporate account. This is very important. The moment the group's money starts entering personal accounts, confusion enters with it. And I always tell clients a simple truth. If it is a group investment, treat it like a business from day one. Now, step 3 is the real engine room, the contracts. This is where most people do not want to spend money, but it is the exact place where spending money saves you from losing money later. The first major agreement is a shareholders agreement. This is the agreement that governs the relationship between everybody. It answers the big questions. Who owns what? Who controls what? Who signs what can a director do alone? And what must be approved by everyone? What decisions require a simple majority? And what decisions require a special majority? Can the company borrow money? Can the company mortgage the property? Can a member sell his shares to an outsider? What happens if two groups are tied and there is a deadlock? What happens if someone dies? Yes, someone dies. Let's not pretend it cannot happen. I handled a matter where a group bought a property informally and one member died. The family of the deceased member showed up and demanded that the property should be shared as part of the estate. The surviving member said no, it is an investment. Because there was no company structure and no clear agreement, it became an unnecessary fight. But when you use a company and you document it properly, the company continues. Shares can be transferred according to agreed rules. The property does not become stranded. Now, alongside shareholders agreements, you need the subscription agreement. That one agreement is showing who is buying shares, how much they are paying, and when shares are allotted. If it is not only shares and some people are funding loans, then you need a shareholder loan agreement. This is another place groups get it wrong. They contribute money, but they do not agree whether the money is equity or loan. If it is equity, it stays in the company as an investment, and members benefit when profit is shared as dividends or the company sells. If it's a loan, then the company owes repayment, and you must agree the repayment timeline, interest if any, and what happens if the company cannot pay on time. Now, some smart groups use a blended approach, part equity, part loan, meaning everyone buys shares with a portion and the rest is treated as a loan, especially when the property will start generating rent quickly. This can be powerful, but it must be written down clearly. Now let us move to the property itself, because this is where millions disappear. Step 4 is due diligence. This is where your lawyer should not rush. Due diligence means you confirm the root of title, whether the property is free from government acquisition issues, whether there are encumbrances, whether there is litigation, whether the seller truly owns what they are selling, and whether the survey plan matches the physical land. And let me tell you something I tell clients. In property, the documents can lie, the land can lie, and people can lie. Due diligence reduces the risks of all three. I had a client group that wanted to buy land because the price was cheap. They were excited. I asked for title document. They said, "Barrister, it is family land, but very safe. The family is well known." We did a basic search and we discovered there was an existing dispute on the land, and there was a history of multiple sales. That cheap land was cheap for a reason. Now, step 5 is the contract with the seller. Usually, you will have an offer letter and acceptance, and then a contract of sale. This contract must protect the company, because the company is the buyer. It should capture the purchase price, the payment schedule, what happens at completion, and the completion documents the seller must deliver. And this part is important. Completion documents are not just vibes. They are specific items. Original title documents, duly executed deed of assignment, or deed of sublease, depending on the nature of the title, survey, receipts, evidence of tax clearance if required in that state process. Where the seller is a company, you need a board resolution from the seller authorizing the sale and execution. Where the buyer is your company, you also need your own board resolution authorizing the purchase and naming signatories. Now, step 6 is perfection, and this is where people suffer later if they ignore it now. Perfection is the process of stamping, consent where required, and registration. Many people stop at signing the deeds and collecting the keys to the property. Then 5 years later, they want to sell or use the property as a collateral, and they suddenly discover that the documents are not perfected. Then they come back and costs have multiplied. So in your group structure, you must also agree who pays for perfection costs and when those costs will be paid. Some groups build a budget line called transaction costs, so nobody is shocked later. Now let me teach you the biggest mistakes I see when groups use a company. They register a company, but they still run it like a WhatsApp group. No meetings, no minutes, no clear approvals. One director is signing things alone. Money is leaving the account without documentation. Then one day, someone raises alarm and says funds are missing. That is how criminal complaints start. And that is how friendships end. So you need governance. And governance is simply a disciplined way of making decisions. Holding meetings, even if it is virtual. Write minutes, record resolutions, set signing limits. For example, maybe any payment above a certain amount must be approved by at least 2 directors. Maybe any decision to sell should be approved by a super majority. Maybe any decision to borrow must be approved by everyone. These are not complicated things. They are normal business rules. Now let me quickly list in plain language the core documents I usually prepare for a group property company structure. 1. Term sheet or promoters agreement before incorporation to capture the initial deal. 2. Shareholders agreement, the big one. 3. Subscription agreement and share allotment document. 4. Shareholders loan agreements if the loans are part of the funding. 5. A deed of adherence so that if new investors join later, they sign and become bound by the existing rules. 6. Board resolutions for purchase, opening bank accounts, appointing signatories, and major decisions like a sale or a mortgage. 7. Property contract or sale. 8. A deed of assignment or a sublease, or a deed of a sublease. 9. Escrow agreements. Optional but very useful, where money should only be released when certain title conditions are satisfied. 10. Property management agreements, if a third party will manage rentals. 11. Your tenancy agreement or lease agreements, if you will be renting out. Now, I want to address the question many people ask. Barrister, why should I bother with all these documents? Can we not just trust ourselves? Let me answer with the story of one of my clients. A group bought a property informally, and one member wanted to travel. He needed money urgently and decided to sell his portion to an outsider. He collected money from the outsider and told the group, "This person is joining us." The group refused. The outsider became angry. The police started calling. Everyone started fighting. If they had a shareholders agreement, it would be simple. It would say whether a member can transfer shares. It would say whether other members have the first right to buy the shares. It would say how the shares should be valued. It would say the process and timeline. So rather than emotional arguments, the documents become the referee. Now let's talk about the biggest pitfalls, because this is what I want you to remember after this video. Pitfall 1. Putting the property in one person's name when it is a group investment. The law may recognize the title holder as the owner, and even if you later claim trust, you will still need to prove it, and proof is not always easy. Avoid the problem. Use a company, or at the very least, document the trust clearly. Pitfall 2. Not agreeing in writing on exit and default. Exit means what happens when a member wants to leave. Default means what happens when a member fails to pay the agreed contribution. If these two are not covered, your group will be unstable. Pitfall 3. Poor due diligence and poor perfection. You can have the best shareholders agreement in the world, but if the property title is defective, you have bought a problem. Now let me close with this. If you are part of a group planning to buy a property, please do not start with excitement. Start with structure. The cost of documentation is always cheaper than the cost of litigation. The cost of doing the right thing is always cheaper than the cost of fixing it later. So if you want to do this properly, you need a lawyer who understands both property and corporate structuring, because this is not only land law, it is also company law, contract law, and risk management. If you found this video helpful, subscribe for more practical legal content like this. And if you are planning a group property purchase and you want it structured professionally, reach out to us through the proper channels. Let us help you do it cleanly, safely, and profitably. I'll see you in the next video.